my recent hearing before the Minnesota Court of Appeals is an oral argument in the quest to make my body cam footage public, which I am opposed to. Not my body cam, the police officer's body cam of the raid on my house that is being propagated by Joshua Moon through his lawyer, Matthew Harden, who I referred to Josh Moon. Hey, what's up, Matthew? How you doing, man? A while back. And he is basically standing in as a proxy for Josh Moon. So he is not actually the guy representing the case. The guy representing the case is a guy named Oliver Bromke, who is a North Dakota attorney who's also licensed in Minnesota. So Josh Moon and Kiwi Farms have been trying to get access to my body cam ever since I was arrested. Like that's been one of their goals kind of from the start, is to get that. There's a lot of privacy issues involved in that I'm not comfortable with. And the law, at least as far as I can read, is pretty firmly on our side on this. But it's a complicated issue. It really is. I don't want to sell it as it's completely it's completely unfounded or whatever. I think it's frivolous. I think an honest read of the law would suggest that they don't have any right to access it. But that's not what they think. And that's the realm of law and justice, right? Is to take a conflict between two positions and find the one that's either correct or sculpt a new one that no one saw coming. So we won at the district court level. Now it's at the appellate court level. And it's not the only case. There's another one too. This is all insane. But hey, it's all educational as well. Have I seen the body cam footage? Yes, I have all of it. Hugo Atano says, didn't the first person who tried to get the body cam from your house a pedo, or am I mistaken? Yeah, that was the first request. The first request that came in for document production was yes, someone who if I remember right, I believe was on Kiwi Farms and also was a pedophile in the sex offender registry. Here we go. This is an audio recording only. So this is an appellate hearing. There's nothing for me to do there. I can't offer testimony or anything. I did not see the beginning of the hearing. So that's when the attorney for Kiwi Farms, Owen Bromke, or maybe Oliver Bromke. That's when he gave his argument. I didn't see this part of it. So this will be fresh for me. I did see when my lawyer made his argument, and just in case, so this is really, this is an interesting thing. Okay. I know everything's so peachy and everything's perfect, and none of this could possibly be true. But if you look here, it's Matthew Harden is the appellant versus the state of Minnesota, who's the respondent, and Nicholas Robert Rekieta, who is also the respondent. That means there's two parties to this. And the lawyer for the state of Minnesota is the county attorney of Candiota County, my county, who just didn't show up. No big deal, right? Just decided not to appear at the hearing. Don't know why. Don't have a reason. If you were an attorney in Minnesota and you don't show up for the hearing and you don't have a damn good reason, they suspend your license or even terminate it if your client complains. Like if it's just out of the blue, or if the judge complains, if the judge is like, hey, where's that guy? They refer you. So he just didn't show up. So luckily, though, my lawyer was able to handle the entire argument. You'll hear about it on the recording. I know you'd like to see it. there isn't a video recording of it. I have a video of my lawyer's part on, but it's all done by Zoom, so it's not like cool or anything. It's just a bunch of faces.
Appeals is now in session. Chief Judge Frisch, Judge Cochran, Judge Kirk, the Honorable Jennifer Frisch presiding.
Good morning, Council. Today is November 18, 2025. Welcome to the Minnesota Court of Appeals. This is the second of 6 cases that we are considering on today's calendar, A25-1039, Hardin versus Rekieta and the state of Minnesota. Council, if I pronounce those names.
Rekieta! The K is before the T and there's vowels. Always, every fucking time.
Names incorrectly, please correct me once your time begins. You're familiar with our proceedings. You'll each have 15 minutes for your primary argument. The appellant has an additional 5 minutes for rebuttal. We ask that you identify yourself and your client before you begin speaking. Also, let us know how we can reference you this morning. These matters are being recorded. That is the only recording that is permitted. And with that, Council, we are ready for you whenever you are ready.
Thank you, Your Honor. May it please the court, my name is Oliver Bromke. I represent appellant Matthew Hardin in this matter. Other parties are the state of North Dakota and Nicholas Robert Rekieta, represented by Mr. White. This appeal centers on the public's constitutional and common law right of access to judicial records in a criminal proceeding, specifically whether uploads to the Minnesota Digital Exhibit System, or MINDES, cited in a party's memorandum but not formally admitted as evidence qualify as public judicial records. The district court initially granted my client, Mr. Hardin's, access to those records, acknowledging their judicial nature, but later reversed course after an ex parte motion.
Okay. So this is the appeals court. Each side gets 15 minutes of time. That's it. That's all you get. 15 minutes. There's no witnesses or anything like that. You get a 15-minute argument. And in this case, the appellant is going first. And so he has taken 10 minutes and reserved 5 minutes of his time, or he will at the end of his argument. One of those two. He's going to reserve 5 minutes to go ahead and do a rebuttal afterwards. But that's all you get. And it is a hard limit. I mean, once you hit 10 minutes, unless you're answering a judge's question and you're answering it very quickly, they're going to cut you off and shut you up right away. Their position, and this is going to become more of an issue as we go. So it's always tough to decide how much to go back and explain on all this. This is governed by 2 basic things. One is in the executive branch, and that's by a statute called the Government Data Practices Act. And then the other is the judicial branch, and that is the publicity and public availability of evidence. Evidence that is presented in a court of law is publicly accessible by default, unless a judge is to seal that particular evidence or seal off the whole case, et cetera, et cetera. And they do that for various numbers of reasons. The question in this case is pretty much strictly related to the judicial side of it. Okay. This is because Minnesota has, during COVID, created an online filing system called MINDES. MINDES is where you file potential evidence. You put it into the system. And then at your hearing, you offer the evidence, and then it's accepted by the court or it's not. And when it is offered and accepted, it becomes evidence and part of the evidentiary record. That's what makes it public. If it does not become part of the evidentiary record, it does not become public. And then it would be governed by other laws. And in this case, the Data Practices Act, which governs body cam footage. Body cam footage is confidential during an investigation, an active investigation, and body cam footage is private after that investigation. Private means to obtain the body cam footage, you would need the consent of every non-government person who appears in that body cam footage. Sometimes they will allow certain people to be redacted out if they cannot obtain consent. But it really depends on the circumstances, how much redacting needs to be done, all of that stuff. But generally, it is considered private data that belongs to the subjects of the data, and it can't be released generally to the public. In fact, if it is unlawfully released, there are significant civil remedies available to those whose privacy has been breached. And those claims are taken against the state of Minnesota. So that's the Government Data Practices Act. And specifically under the Government Data Practices Act, hope you're listening, there is no state immunity or qualified immunity. They do not get to have immunity under the Data Practices Act if something is private and it is leaked. Like, say, when you're arrested and someone leaks the confidential and private police report, maybe by taking a photo of it from the sheriff's office at the county and posting it on Twitter. If that happens, for example, each plaintiff has a civil remedy of any economic damages, any specific damages, and also a statutory remedy of $1,000 to $15,000 per plaintiff, unless the court determines that it's willful, in which case that's doubled to $2,000 to $30,000 per plaintiff. So if, for example, you were to release a document that, say, impacted the privacy of 7 people, hypothetically, that is up to $30,000 a person in special damages, in addition to any economic damages, reputational harm, all of that stuff, and it can get very, very expensive for the government if someone happened to do that. I don't know why. I don't know why I would bring that up. That's the Government Data Practices Act. This portion is again under the judiciary. Their claim is that this became part of the evidentiary record. Now that's really muddied up because the Minda system, like I said, you upload to the Minda system, and then after a hearing, evidence is either classified as evidence or not. And in this case, the court clerk or court administrator, whoever, someone from, I don't mean the court administrator as an individual. I mean someone from the administrator's office, mislabeled the body cams as evidence. Two of the body cams that were in the system were mislabeled as evidence. So the claim by Oliver Bromke is that as they were mislabeled by evidence, now they are public, which has some legal problems with it that will become apparent very quickly. I apologize for going through all this backstory in like a really convoluted way. It's hard to, this is a really complex legal issue, and it's a novel legal issue. Like this doesn't happen. These claims don't happen because the courts aren't ready for social media. I've been saying that for years and years and years. They are so far behind on technology. They're not ready for what social media is.
By the state to correct the record, denying access without allowing Mr. Hardin a chance to be heard. We're asking this question.
Mongoose Dog says, how long are you going to milk this? I have no control over when this ends at all. I don't have any control over this. This is a case brought by Joshua Moon. He could stop pursuing it at any time until he stops pursuing it. I will fight it.
Court to reverse that denial and remand with instructions to grant access, or alternatively to afford Mr. Hardin a hearing to rebut the adverse factual findings made against him as an intervener.
Counsel, before you get in.
So this is the other part of appellate arguments that you may not be used to if you don't like. This is different than district court. Remember, this is you as the lawyer talking to a panel of 3 judges. You stand before them and you have your 15-minute speech prepared and you start saying it, and then they interrupt you and ask questions and your speech is derailed entirely. So that will happen.
To the merits of the right to the information itself. I have some questions about the procedure that was used here. I don't see anything in the rules of, I mean, this is a criminal proceeding. That's the underlying proceeding. I don't see any mechanism in the criminal rules that allows a private third party to intervene and for this purpose or any other purpose.
Okay, so this is another procedural aspect of the case that is weird and without legal foundation. Joshua Moon's attorney, Matthew Harden, made a motion to intervene in the criminal case. Now, there is no rule allowing intervention in a criminal case. You could see the problem with intervention in a criminal case. Intervention is where a party makes the claim that they have a legal right or a legal, necessity to be a part of the case, so that they will better represent what is going on than a named party. So that's intervening. Impleading is bringing someone into the case as an addition. Intervening is to stand in front of some other party. So Matthew Harden attempted to intervene in the criminal case. The problem with this is, imagine if you could intervene in a criminal case on either side. Well, nope, I'm more responsible than the defendant. That doesn't make, I don't know why someone would want to do that, although they could show that, they're more responsible, but they're not guilty, and then let the defendant who may be guilty go free, I guess. The other thing is, imagine if you could intervene on behalf of the state. If you could intervene on behalf of the state, then you basically allow private prosecutions, and that's something we don't typically do. A couple of states have some ways to do something like that, but they're the ones that are around are archaic and draconian and going away, because we don't let individuals use the criminal apparatus of government to go after other individuals. That's fucking insane.
Can you point me to some authority that allows for that procedure in a criminal proceeding?
Sure, Your Honor. Intervention is the canonical vehicle for third-party access enforcement. I believe the case I cited was Providence Journal, especially when there's a First Amendment issue lurking here. Criminal cases demand public scrutiny to keep the system accountable, especially in situations like this one where it appears.
So this is a conflation that we'll see a lot of going through. And I'm sorry, I'm going to offer a significant commentary on this because it's really frustrating having to have other people do this for you. It's frustrating. But that being said, they are claiming that the public has a right of access to the case. And that's going to be kind of the largest part of their argument. And that's true. The public has a right of access to review court records in criminal cases. The problem that they're skipping and they're really trying to avoid is that this isn't part of the record. So the reason that there's a right of public access to review criminal trials is to make sure the government isn't fucking somebody over by prosecuting them under secrecy, like using the FISA court, for example. When the FISA court is used against you, you don't even have access to the FISA court documents or the decisions that the FISA court is relying on to make its rulings. It's really difficult to fight, and you have to hire a specialist attorney with certain security clearance, and he can't talk to you about anything. He can only draft the confidential motions, which would be classified. It's kind of wild. But the public does have a right of access. I know the FISA court exists, but they have a right of access to make sure that there's not some government abuse going on in the prosecutions. Now, that requires something to be part of the evidentiary record, though, because it has to be used against the person to be reviewed. And they're going to try and make the claim that this is some sort of hidden document that was used to prosecute, which it isn't at all. A hidden document that's used to prosecute. That claim is actually stupid because the people who were potentially going to use this was going to be us. So that wouldn't be used in the prosecution. It would be used in the defense, in which case the right of public access maybe doesn't apply. That's a bigger issue that doesn't get addressed in any of this, as far as I know. It would be kind of the next step argument if that were the case.
That the prosecution.
Eric Duff says Bodycam footage is available through FOIA requests. No, not in Minnesota. It is in Florida. People think that you can get any Bodycam footage that's out there, because so much of it is from Florida. Florida is called the Sunshine State for multiple reasons. One of them is that they have a very open records policy. Minnesota does not have that same policy. Minnesota body cam footage is only publicly accessible if an officer discharges their weapon in the body cam footage, or a civilian dies in the body cam footage. Then, like, those are open to public scrutiny, right? Which makes some sense. But otherwise, in Minnesota, body cam footage is private, which means the right of privacy is held by the subjects of the video. Individually, every single one of them, which means any non-government person captured on a body cam video must give consent to have the video released.
In the defense in the underlying criminal case were of the same mind and filed a motion that both of them constructively adopted.
But the mechanism in that case was not intervention in a criminal case, was it? I'm just not aware of any authority that allows a private third party to intervene in a criminal case to seek the kind of relief that you're seeking. I mean, I'm putting aside the question of whether you have a right under some other procedure. I just am questioning whether this procedure is authorized by law or our rules.
Well, the right to intervene here, it flows from the constitutional right of public access itself. Under the cases I cited, Sargent and Ledoux, procedural rules.
Ms. Jessica MB1 says, so all documents essentially sealed until it's admitted for the court. They're not sealed. Sealing is a little bit different. Once it's sealed, nobody can release them during the pendency of the court action, or the pendency of the order, I should say, the sealing order, which is actually possibly an interesting question here. And as you remind me of it, I'll have to mention it to my my lawyer, I'm guessing, because it might need to be, I believe there's maybe some supplemental briefing that is going to happen, and this is probably relevant and maybe overlooked. The body cam footage itself is actually part of a sealed case. So that's a different problem altogether. But a sealing, an order sealing certain things means they cannot be released by parties to that case, or actually by anybody. So who's under the court's jurisdiction. So you've got an issue there in that. But documents, if a case is not sealed though, and something's not evidence, it can be released. It's just permissive. The people who own the right to the document own the right to release it. In any other way that it could come out is applicable. But they're not pursuing some other method, right? Like, no one's called me up and offered me X amount of money. I would still say no, but no one's called me up and offered me X amount of money, for example, to release the document. In theory, like, someone could do that, or I could choose to release it. Well, it's not, the videos, but that's not happening here. They're asking the government to release it, but the government doesn't hold the right to release it. And that's a critical element of this. Now, if it becomes part of the evidentiary record, if it's admitted to and accepted by the court, offered to and accepted by the court and admitted into evidence. Sorry, I said that wrong. If it's offered to the court, accepted by the court, and then admitted into evidence, then it becomes part of the evidentiary record. That is public unless it's otherwise sealed. Sorry, it's kind of confusing, but trying to answer these questions the best I can.
But Mr. Bromke, I think the question is there any rule of criminal procedure that allows for intervention in a criminal proceeding to access court records?
I believe that the district court, in the order that allowed for the intervention for the limited purpose, specifically pointed to the common law right of access with respect to its basis for allowing Mr. Hardin to intervene for purpose of making the request that he did.
And I think the court noted that there wasn't any specific rule of criminal procedure that would allow for intervention, correct?
I believe that is the case, yes.
And so isn't there another procedural mechanism that is available and provided for, which would be a petition for a writ of prohibition or a mandamus to seek access to judicial records, as has been used in some of the cases that you cited?
Had the court outright denied our request, we would have sought relief.
So what he just said was that the district court denied their request. The district court didn't initially deny the request when it was mistakenly labeled as evidence. The district court did allow 2 people on behalf of Matthew Hardin to see the body cam footage in person. That was not lawful. I don't know what else to say about that. That was not a lawful act, but you do what you do.
In that manner, but in the interest of judicial efficiency, we sought access this way instead.
And you can still seek access through regular civil proceedings, yes?
Yes, but with respect to challenging adverse factual findings in the writ of mandamus context, I'm not exactly certain how the court expects us to do that necessarily. It's just a.
So this is an interesting question and answer exchange. The judge, the appellate judge, remember, this is limited to, is this a question, or this is a question for the judicial access to the court records. If they're not court records, you have to use some other process. And the judge who's asking him a question says, hey, why aren't you, can't you just go through the other processes for this? He has to tread kind of carefully, because his answer is yes, but the law is pretty fucking express that they don't have any right to this footage. And so he's saying, yes, but I don't know how the court would expect us to do this, which means we know we'll get butt fucked if we try. They have a problem. The problem is they don't have any legal authority to support their position. Dragon Red says, Nick, you still have not commented on these judges. These are the personalities that would otherwise drive you nuts, but you're letting it slide. Well, 2 reasons. One, I've, a vested interest in not commenting on the personalities of the judges. 2, I didn't really there's not much to the personalities of the judges. There's the chief judge of the appellate court is sitting in this one. I don't remember her name. The judge who's talking now is not the chief judge, but she does most of the questioning throughout. And then there's those 2 are females. There's a male judge. He doesn't ask too many questions throughout the hearing. But as far as their personalities, I don't know any of these people. I don't watch any of their other things. I'm not sure what their judicial perspectives are. Right now, they're asking questions based on the briefs that were submitted. And the questions they're asking this guy, which is Oliver Bromke, all revolve around 1, why are you trying to do this through this process? 2, they're going to get to the questions of, do you have any legal foundation anywhere for any of this? And his answer is good.
Constitutional principle that we're asserting here.
I understand, counsel, but it does seem incongruous for a third party to be seeking a civil remedy, which, the collateral consequences of which delay a criminal proceeding. And I have constitutional concerns about that also.
Well,
is there any jurisdiction anywhere in the country that allows for this kind of procedure?
In terms of, you previously asked about whether Minnesota specifically allows for it. Minnesota rules of criminal procedure don't explicitly incorporate a remedy of this type, but many jurisdictions, including the federal courts, routinely recognize it. And we cited that in the district court brief.
Routinely recognize what? A right of intervention in a criminal case?
Well, for the purpose of seeking public access to court documents.
What's the
So the judges here, notice the judge's kind of incredulous tone there, because he says very casually, oh, this is commonly done. It's not. Let's get that out there right away. This is not commonly done. And it's much less commonly done in Minnesota. Where it is the most commonly done involves cases against, like, the FBI. It typically, I mean, we're talking most of the cases. In fact, I think all of the cases that they cite in this, none of them are from the 8th Judicial District, or the 8th Circuit. I mean, none of them are from the 8th Circuit, which is where Minnesota is. We're talking 2nd Circuit and, federal courts in general, because they're typically against the federal government, who has national security interests that make some things secret. Those things, that's where the right of public access comes in. Hey, you can't prosecute people under secret laws and secret rules. State governments don't do that so much. State governments may have corruption, right? State governments may prosecute people with corruption. We saw in the Karen Reed case, there's likely a lot of corruption going there. It sure didn't pass the sniff test, so we can infer that. But it's not because there's a secret rule or secret documents that the state of Massachusetts was using against Karen Reed. It's that you had a corrupt judge that was connected to a bunch of crooked cops, right? Like that's what's going on over there. In the federal government, there are literally secret laws. There are laws and rules that pertain to national security, procedures that have to go through people that cannot be named. Their identities must be kept secret, CIA agents, foreign intelligence officials, and stuff like that. And so frequently, the federal government is involved in using documents that are not publicly available. And that is where this proceeding that he's talking about, this right of intervention into a criminal procedure, comes into place more frequently. That's when you go, hey, you don't get to do this. The public gets to see why you're going after this. And he's going to cite cases. Almost all of these cases involve the prosecution of terrorists, because that's who runs into this issue the most. Hey, we have national security issues. We're prosecuting foreign actors or foreign combatants. And that has its own set of complications. They're trying to conflate that with body cam footage in Minnesota that wasn't used in the criminal case at all. And that is going to be the problem. So he's casually saying, oh, this happens all the time. And she's like, oh, really? Does it? There's not a rule for intervention in a criminal case in Minnesota. It doesn't exist. In fact, there's not a federal rule for it, I don't believe. If there is, it's the Federal Rules of Criminal Procedure. I haven't read through them. I didn't practice since law school. I didn't practice in federal court. So, I don't know off the top of my head if there is a rule about that. If there is, it's one of the obscure ones. This is not a procedure that's done with any relative frequency.
What's the best case that stands for that proposition?
Apologies, looking through.
He's looking for it.
Or is there a rule of federal criminal procedure that allows for intervention for purposes of by a third party for purposes of obtaining a civil remedy?
This long period of silence where she said, do you have a case? And then after 20 to 30 seconds of uncomfortable silence, is there a rule? And he's still quiet. This is not where you want to be in front of the appeals court. You do not, you should, if there's a case on this, he would have it, presumably.
I mean, Mr. Bromke, you can see what our concern is. I mean, this isn't the only criminal case where there's evidence that is produced, and I have concerns about allowing for civil intervention that would necessarily delay criminal proceedings as a matter of procedural course, which is probably why we don't have a rule of criminal procedure allowing for it. So why would we allow this kind of procedure to occur as opposed to directing your client to engage in regular civil remedies?
Because the result is going to be the same regardless. We're going to be arguing about the same issue, and this is simply the most convenient forum in which to litigate it, given what's already been filed.
I mean, the result might be the same for you, but the result is not the same for a criminal defendant. Wouldn't you agree?
Well, that's true, but in this case, the underlying criminal case is already more or less concluded. We've gotten past the disposition phase. The state is arguing we're stopped by this criminal order from making arguments in the civil case. So in terms of who this materially affects, I would say that it's us.
Can you point me, let's just turn to the merits for a moment. Can you point me to where in the rules of public access to judicial records that indicates that a document that was never received as an exhibit, was never, there was an administrative error in entering the document in Mindy's, that administrative error would render the document an exhibit for purposes of determining whether it is a public record?
Well, the public access laws talk about what's presented, not what's offered and accepted per se.
Okay, before he gets into this argument, which is interesting, although it's terrible, the judge here is very clear. Everyone acknowledges that the labeling of this body cam footage as evidence was a mistake. It was an error. The court remedied that error. The judge issued an order, says, okay, no, this is not evidence. It was not offered. It was not accepted. This is not part of the evidentiary record. Very clear on that. So judge is like, so this judge, the appellate judge, is like, okay, so we're all clear that this was a mistake, and the court then remedied the mistake. Why does that error suddenly grant you access to this thing? And mind you, what Bromke is doing here is a very crafty technique. Bromke is using concepts of public access to make sure the prosecution was legitimate or whatever, right? That's what he's saying. That's a lie. That's a bald-faced lie from Bromke. He is lying to the appellate court. He's lied to the district court. That is not the purpose of this. Josh Moon, who has hired Matthew Hardin to do this as his stand, as his proxy, has openly stated that is not the intention of obtaining the body cam footage. The intention of obtaining the body cam footage by Joshua Moon is to air it publicly for the purposes of what he perceives will be humiliating me. So to go before the appeals court and to say that what you're doing is trying to make sure a prosecution was valid, especially in a case where there is a guilty plea to the facts that were effectively laid out, at least insofar as the drugs are concerned, there is no need to validate the prosecution because a plea agreement was reached and I admitted to the facts that were alleged against me, to wit, that I was in possession of a mixture of approximately 19 grams of cocaine, a mixture of cocaine, Molly, and ketamine. Now, it wasn't mixed. It was in separate bags, but for the purposes of prosecution under that possession law, they consider it all a mixture of the same thing. So under that, the facts are not in dispute between the two parties. So the question that this was somehow, that they're somehow acting on behalf of the public and making sure that there was some sort of meritorious prosecution. Well, we know there was a meritorious prosecution because I and the state agree that the prosecution was meritorious insofar as the facts as presented. I did not complain or challenge the body cam footage itself or anything in regards to the factual record. What I challenged was the validity of the warrant. those are different things, right? The execution of the warrant is because the validity of the warrant is in question, but how they executed the warrant and what they found was not challenged. We didn't get to any place where we could challenge that, and I then admitted to those facts and pled guilty. So he is doing this legal ninjutsu. If this were like a Discovery documentary, it'd be something like that. They'd say, "Now use legal ninjutsu to flip the script here." The person who wants the documents to remain private is the privacy rights holder, which is me, right? The government doesn't have like any specific position on it other than what their legal obligations are. I don't think they care one way or another. Like if I tried to release them, I don't think the government would be opposed. But they don't have any right to release them on their own. So he's trying to use procedures and arguments that are geared towards wresting control of documents from the government to wrest control of documents from private citizen. And it's very dishonest that he's doing it, especially when his client's client, who his client is standing in proxy for, has openly stated the opposite intention on multiple occasions. Not like that's ever going to come up again.
Into the evidentiary rules, presentation is a broad term. You've got Minnesota's rule on sanctions, for example, saying you can't file or present to a court a motion without 21 days notice. It's got to be considered a distinct concept from offering, or else it's surplusage. Here, the body cam footage at issue was presented by a criminal defendant, Nicholas Rekieta, in support of his motion to suppress, in which he accused.
Well, it wasn't presented, though. It was cited in the motion. And my understanding is typically in a criminal proceeding, a legal brief framing the argument that will be, the legal argument is filed, but the actual exhibits are not filed. They are offered at the hearing. Now you can talk about that in your response, but I don't think it was presented. I think the record reflects that it was cited in the legal brief and uploaded into Mindy's. And as you know, Mindy's is a newer system, and there is a Supreme Court order. Mongoose
Dog says you wouldn't be acting this worried if they were losing. Mongoose Dog, I don't know how to better explain this to you. They lost. They lost at the district court. That's why they have appealed to the Minnesota Court of Appeals. And they really have a problem with their arguments in that they don't have legal support for it. That's not me being worried. That's the facts of the matter. And it will be basically discussed by the judge and lawyer here in just a minute that he has no legal authority. He's going to cite to a case called FAREH, F-A-R-E-H. I think it's U.S. v. FAREH, F-A-R-E-H. And that will be his support for why you can intervene in a criminal case for access to secret documents. But we're talking about, again, publishing some or going after someone for, if I'm not mistaken, being members of ISIL or ISIS, and the government having policies that they were enforcing that were not public. This is a completely different question, and that's the best case they have on point for it. And again, that comes out in the hearing if you'll listen. Look, I've said from the start, I believe that they don't have the legal foundation for it. I'm open to hear the legal foundation for it. I think they're going to lose, but this is a new issue. There's no Minnesota support for it. There's no 8th Circuit rulings on this, and there's no Minnesota state level rulings on this. There's nothing. This is a relatively new process. And part of the reason for that, though, is because Mindes is a new system. It was implemented in 2020. And so an error with Mindes, the appellate court, I guess, could try and decide that, an erroneously labeled item in Mindes is sufficient to allow the release. The appellate court is going to explain here, and I know you haven't listened to this, but I have. The appellate court's going to explain here, though, that the Supreme Court has made a specific ruling that items uploaded to Mendes, but not offered and accepted into the case, are not part of the evidentiary record. So, and the court's going to ask him, how are we supposed to go against the Supreme Court? That's not the role of the appellate court. The appellate court's role is not to go against the Supreme Court, it's to uphold what the Supreme Court precedent states. So you've got a problem here. The problem is they don't have persuasive authority on their side, except one case from the Second Circuit, which involves a completely different question involving federal prosecution of foreign agents. That's the closest they can come. They have nothing from Minnesota. And on top of that, you have a specific Minnesota Supreme Court case that says the opposite of what they want. It's crippling. Does that mean I'm going to win? No. This is court. As I've said for the entire duration of this channel, you can be very confident on the law and the facts and still lose because it involves people. It involves people making decisions. It involves people being persuasive. It involves people being persuaded. There's a human element to law. And as long as there's a human element to law, you always are going to have a degree of uncertainty. Am I pretty confident that we'll win? Fairly confident, yes. The law is pretty clear at this point. Does that mean we will? No. But we'll see. So far, we won at the district court level. We'll see what happens at the appellate court level within 90 days.
That which says specifically that exhibits in Mindy's offered in court proceedings are case records. Exhibits uploaded and stored in Mindy's but not offered to the court are not case records of the Minnesota Judicial Branch as defined in the rules of public access and are not publicly accessible.
There it is, right there. It's not publicly accessible.
So
Right. Oh, sorry.
I think the question is not whether it was, you're using the word presented. I think the real question is whether these video exhibits were ever offered.
And I would take a different position. Offered and received are evidentiary terms of art. They govern what becomes part of the evidentiary record for purposes of proof at a hearing or trial. But the right of public access doesn't turn on evidentiary admissibility. It turns on whether a document is presented to the court for purpose of influencing a judicial decision.
Now, okay, so the rule is about offering and accepting. He's saying that there's a rule that says presented to the court. Importantly, this wasn't presented to the court. This wasn't at any time actually presented to the court in the case that they're talking about, which is the Minnesota criminal case against me. We had put it into Mendes, which again is just a digital evidence onboarding system. That's all it is. It's the place where you put your evidence so that when you're in court, you can offer to the court this digital evidence. They implemented it during COVID because people weren't there in person to hand a document to the person sitting on the witness stand, right? Okay. So we uploaded it to Mendes. When we went to the omnibus hearing, which is where this issue might have come up, the issue in question was the Sixth Amendment rights being violated for April. We had made an argument in our motion about that. However, that portion of the motion was mooted as the court asked both my lawyer and the counsel for the county, and both of them said this issue, we've actually come to an agreement on this issue. It's not necessary for the court to address it. He's trying to say that because the body cam footage is cited or referenced in the motion, that the body cam footage itself was presented to the court. And he's making a distinction of presenting versus offering and accepting. What he's glossing here, and this is how you do law. Okay. He's not doing anything wrong with this. It's not like unethical, but he is glossing something here, is that presentation is also an evidentiary term of art. He's glossing past that. Presentation of evidence to the court is for the purposes of the court determining admissibility. We didn't even get to that stage. This was never presented to the court for the purposes of determining admissibility, nor was it offered to be admitted, nor was it accepted and admitted. So none of the things that need to happen happen. He is trying to gloss that presentation term and ignore that it is also a term of art in evidence. And that's a really important failure of his argument, because if the appellate judges go back through the transcript or through this, I'm sure they already caught it, but if they go back through, they're going to say, yeah, he kind of like skimmed over the part where it's not presented anywhere to the court. That never actually happened. So even if the rule were expanded to allow it to include presentation, where the court has reviewed it to determine its admissibility, he's still got a problem.
And what case are you citing to? Because I think the case law talks about documents being filed, not presented. So what case or rule are you relying on when you're using the word presented?
And the important part is his answer right here. So you're saying that it's presented. What case or rule is it?
The specific issue at hand here is so new, given the newness of Mindy's, that I don't believe that there is a specific Minnesota Supreme Court case or appellate court case on point to that issue. But
okay, so there isn't a case. So he made up that argument out of whole cloth. Like that was all something that he made up. I don't know how to state it further. This is a huge problem for their case, and it shows up over and over and over again.
Distinction is built into.
Aren't we guided by the Supreme Court's order? I mean, why wouldn't we follow the Supreme Court's order that says that unless a document in Mindy's is offered, it's not publicly accessible? We are an error-correcting court. We are bound by Supreme Court orders.
That's what I was mentioning earlier. The appellate court is explaining to him, he knows this, I'm not trying to suggest that he doesn't, that they don't have the authority to change, the Supreme Court ruling. Like that's not what they are for. They are to correct the errors of the district court in applying Supreme Court precedent. The Supreme Court has a ruling on this. He's saying that ruling is wrong. That's fine. But if you're saying that the Supreme Court ruling is wrong, you either have to say that it goes under a different rule, or you're going to challenge it at the Supreme Court level. And that would only be if the Supreme Court decides to take up the issue.
Because the distinction is important for preserving the right of public access by interested individuals and holding the holding the parties to a criminal action accountable for what they filed. The distinction matters because presenting is the functional act of placing a document before the court to adjudicate rights. But
you have no legal authority to support your position on presenting.
The Minnesota Government Data Practices Act specifically says
you don't have any authority. Notice he didn't say I do. He starts talking about the Government Data Practices Act, which does not cover evidence. We'll hear that in a second.
Says presented, items that are presented are public. It doesn't say anything about offered versus accepted.
I mean, the Data Practices Act doesn't apply to judicial records.
Granted, but I'm referencing that for the purpose of establishing that there is a distinction between.
So what he's doing, his reference authority for saying that presented is distinguishable from offered and accepted, which offered and accepted comes from the Supreme Court ruling. Presented comes from the Government Data Practices Act, which is completely different than what he's doing now. He can, and they are, also trying to go at this through the Government Data Practices Act. The problem with that is they know that they have an even worse argument under that act.
Them here. I mean, regardless of what the Supreme Court has specifically said about
and in the Supreme Court's rules of public access, does it draw the same distinction?
It does not, to my understanding.
Counsel, why can't you just handle this as a data practices case?
It's being handled as a data practices case, but unfortunately, we are currently waiting for that to resolve. Whether or not that case proceeds and how it proceeds is going to probably depend on the procedural posture of this case pending this.
Lounge King 77 says, you being guilty doesn't mean the plea isn't coerced. Who's suggesting the plea was coerced? I've never suggested that. No one I know has suggested that. No one who knows me has suggested that. Josh Moon's lawyer hasn't even suggested that the plea was coerced. That's not an argument that's before the court in any way. You're right. So I mentioned that earlier. Just because someone pleads guilty doesn't mean that it wasn't coerced or somehow improper. No one's actually alleged that here. Like I said, instead of alleging that, what they're trying to do is just ride this parallel idea and hope that the appeals court doesn't notice. Guess what? The appeals court is like pretty observant of the arguments brought before it. Now, it doesn't mean that they will definitely notice, but they're pretty good at issue spotting. That's why they're judges. So we'll see. NY Renal MD says it seems to be private until the investigation is complete. There are specific terms around this. It's actually confidential until the investigation is complete, which means even the subjects of the document cannot have access to it. So during the investigation, I can't even request the body cam footage. It is given over in discovery, which is separate because I'm being prosecuted. Let's pick someone who's not being prosecuted. Let's say they chose not to prosecute April, for example, right? Because initially they dropped the charges against her. It was apparently a clerical error. They meant to charge her, but they didn't. But let's say hypothetically that they didn't want to charge her for whatever reason. So they didn't charge her. So she wasn't being prosecuted in the hypothetical situation. If she wanted to have access to the body cam during the investigation, she would not be able to get it because it would be confidential. And the only tool available would be discovery. And if she's not being charged, she's not entitled to that discovery. So that's confidential. 90 days after the investigation is complete, body cam footage moves from confidential status to private status. I'm only being pedantic about this because the law is pedantic about it. You said it was private until the investigation is complete. That's not accurate under the law. It's confidential, which is a higher level of privacy. In which, well, it's not private at that point. That's where the government holds all the rights to it. After the investigation and 90 days, it becomes private, in which the individuals who are the subjects of the body cam footage have the rights. And that's every single non-government individual in the body cam footage, including if it was on the street or whatever, it would be passersby and stuff like that. They would have an individual privacy right that would say that footage cannot be released without their consent. Now, again, Minnesota allows for limited redactions. If there's like an incidental viewing, again, you're talking about someone on the street, for example, passing by, where they would, maybe redact their face if they're not involved. If it's not really possible to completely redact out someone, then they can't release it without their consent. But that's private. Okay, so there is a distinction there, and it's an important one. Like I said, not trying to be pedantic, but the law is.
Hearing. So,
But I mean, what at this point, if the investigation is over, what basis would law enforcement have to claim that it's not a public record under the Data Practices Act?
wonderful question. If you could ask the same question to the district court judge in that case, we would love it. But the findings there are adverse findings in this criminal order that we're appealing. In terms of the specific data that we're requesting, there's some, I guess, not quite, there are some minor children that are involved in the footage that would create some pause for law enforcement from releasing it. And we made Government Data Practices Act requests and they were denied. And that's currently the subject of civil litigation.
They were denied because the Government Data Practices Act is explicitly clear on the release of this type of information, the whole section on body cam footage, and it suggests that they should not have access to it.
So, counsel, in your view, when did these video exhibits that were never formally offered, when did they become judicial records in your view?
At the point at which the district court reviewed them for the purposes of at the point at which the court reviewed them after they were filed by Mr. White in advance of the omnibus hearing, when the court took a look at what was filed and said some of this is properly brought at the motion in limine stage.
So this is a lie by the a lie, misrepresentation, lawyering, whatever you want to call it, by the opposing side. He's saying that the judge reviewed this and used his review of it to make a determination because the judge used words that my attorney wrote in his motion to say, they're or in a prior motion, which was a request to deny, like a opposition to media access or something like that, in which it was mentioned that there are children present in the video, unredacted faces of children, and that it would be improper to release it. So the judge relied on those statements and made this determination. He's trying to say that the judge reviewed the video. Now, this is another thing of lawyering that's going to come up, although it hasn't come up yet. Oliver Bromke is again going to misrepresent to this court what happened at the district court level, because he is going to say that the judge, he's going to try and conflate and confuse the appeals court into thinking the judge reviewed this video by citing the judge's words in a different proceeding in which the judge did review the video at the request of Matthew Hardin. So Oliver Bromke is going to suggest that because his client requested a video and a judge reviewed it in that case, which is after my sentencing hearing, that created it as an evidentiary record that could be released, even though the review was to determine that the finding the videos was in error, or in the administrative case. There's multiple cases on this, and he's going to try and conflate that for the appeals court, which is not a good move, because if the appeals court catches on to what he's doing, they're going to be really pissed off about it. Now, that won't happen at this hearing. That would be something that happens on review. But when they realize that he's actually talking about a separate thing and trying to represent it as this thing, they're going to be annoyed by that. Will it influence their decision? I don't know. Again, I think the legal foundation of this is firmly in our court. It's pretty obvious to anyone who reads the law and understands it at all. And even it's pretty obvious to Bromke that he doesn't have the foundation here. But hey, who knows?
But then at the pretrial or at the
Mongoose Dog says Nickstown hates him. The footage is going to get released. You guys keep running with that. Like I hope it works out for you. You all say it very confidently.
This hearing stage, and then certainly later on.
That was after they were mistakenly marked as admitted.
No, before that they were mistakenly marked as admitted.
Well, the request for access was after the omnibus hearing.
Right, but you asked my position on when they were.
Yeah, and maybe I misunderstood your response, but I thought you said it was when the court reviewed them, and I thought the court reviewed them for determining providing public access.
They did, yes, on May 1st as well. There's another.
I was sentenced on April 18th. The May 1st request was later, right? And so he's saying May 1st as well. But that's the only time it happened. It didn't happen at the omnibus hearing, which would have been months and months and months prior. He knows it happened in May 1st. That's when the judge reviewed it. Of course, it was the same judge. So it would be interesting that the judge would need to review that footage that he's already seen and is part of the record. But again, this is where he's trying to do some sleight of hand before the appeals court. Considering the appeals court judges and their clerks will go back through this transcript or the recording and go through this stuff if they have any questions about it, this is not a great strategy. It's hard to hoodwink the appellate court judges because, again, they have a bunch of time to put together their opinions and they have a bunch of other people who are looking at it at the same time.
Order. There's two separate times at which the court reviewed the evidence that was submitted by Mr. White. One was during the criminal case when it was ongoing, and then there was afterwards.
Wait, I'm sorry. When are you saying exactly the court reviewed it during the criminal case?
In advance of the omnibus hearing at which it determined that the issue that Mr. White had brought up was more properly brought as a motion in limine issue.
And what's your basis for saying that the court reviewed it? Because the court in its order said it didn't rely on those exhibits.
Because the statements that were made by the court specifically say that it was motion in limine issue, not omnibus issue.
I don't know that that means the court reviewed the exhibits. I don't think the court actually said that in the transcript. So you're inferring something that isn't expressly there. Would you agree with that?
Not necessarily, no.
Can
Not necessarily. You're inferring something that's not expressly there. Do you agree? No, not necessarily. Well, then it has to be expressly there. Can you point to where it is? And
you point me to where in the transcript do you think the court said it reviewed the exhibits?
Well, it did that in advance of the May 1st order, which it specifically stated. It described what was the content of the video.
Well, where in the record can you point me to support your view that the court reviewed these exhibits prior to the omnibus hearing? You need to support your position with the record before us. That's what our review is limited to.
Apologies, reviewing the transcript here.
Because we're familiar with your briefs, we're familiar with the transcripts and the record, and I don't recall that, but maybe I'm just not recalling it at this moment.
she's not recalling it because it's not there. Because again, if it was there, he would have this prepared. This is a core pillar of his argument. And he doesn't have any authority, and he doesn't have citations to the transcript or anywhere else in the record. All he has is this inference that he made, and again is trying to breeze past the appellate court judges. But the appellate court judges are good at doing this. This is what they do. Issue spotting is the primary function of the appellate court. Issue spot and then apply the rule. The question is, what is the rule that needs to be applied? After that, it's just math. The appellate court isn't there to interpret or change the rule. It's, is this rule appropriate? Apply the rule.
Well, you can answer on rebuttal. Your time is up. Thank you, Chief Judge.
Ouch. You never want to go out like that, right? Like, he went out not answering the last couple questions, and it was a pretty long accumulated time of silence, well over a minute of silence from him, other than to say, no, not necessarily, in regards to whether he it was explicitly in the record or not. That's a crazy answer for him to give. If you are preparing an appellate argument like this, you have this answer. You know exactly what's coming. Cyborg Valkyrie says, be fair, this guy is about as well prepared to present a reasoned legal argument as Kurt is. Look, I don't know Oliver Bromke from a hole in the wall. I don't know anything about him. I don't have anything positive or negative to say. He's a lawyer from North Dakota who's licensed to practice in Minnesota. Perfectly fine and reasonable. What I do know is that he's got a very tough legal argument here because he doesn't have any support. So I don't want to say he's not prepared. It's not that. It's that there isn't something to prepare. His position isn't supported. And so you have to kind of, now this happens a lot. And again, it doesn't mean that you ultimately lose on the issue, because what it means is you take a beating at this stage. You take a beating at the Court of Appeals. Now, maybe they then go to the Supreme Court of Minnesota. Minnesota Supreme Court accepts the case. And when they hear it, at that point, he makes this very compelling public argument about, or, public policy argument about why it should be allowed. And the Supreme Court reverses course and changes their existing ruling. That happens. I mean, it fucking happened in Roe versus Wade at the U.S. Supreme Court level, right? And then lost every step of the way until they get to the Supreme Court, and then it changes. So, like, you take a beating at the appeals court when the existing precedent isn't in your favor. That's how you change the precedent. So I'm not making anything like, he seems to be well prepared as far as you can be. There just isn't anything to prepare. There's no Minnesota case law on this, and there's no analogous case law that's favorable from Minnesota or the Eighth Circuit. And then the closest analog he has nothing to do with this issue. So he's just doesn't have anything. That doesn't mean that that you won't get your ruling. In this case, though, this isn't a massive public issue. This is a very niche public issue that involves a very dedicated group of people going after someone who isn't challenging the police narrative or anything like that. As far as the details of the crime that I was charged with and the crime that I was ultimately convicted of after a guilty plea. So you've got a huge issue in that there's not like a massive clamoring for this. There's not public outcry about this stuff not being available. And there's a very simple and logical reason why. Because when there's an outcry of this stuff to be available, is because the outcry is typically coming from the defendant or from the victim of police brutality or police use of force. It's usually the state is holding this footage going, fine, like, you're the subject of it. Here you go. And we want the body cam footage released. If I wanted the body cam footage released because I thought the police acted like in some sort of way, I could just I could release it. I have it, or I could sign, the documents and have I could get everybody's consent and I could have them release it. Like that would be there. It's not like the government is holding this back because the government doesn't want people to see. They're holding it back because it's the law. That's a huge difference between a use of force incident or, an allegation of excessive force or coercion or some, improper prosecution. Those are different. There's different postures from all the parties involved. This doesn't happen because this isn't about that. That is pretextual and it's false. Again, the person perpetrating this has openly stated that that's not the actual reason that he's doing it. When that happens, you create this issue. And if you're going to go to the Supreme Court and be like, and tell them this highbrow notion of nobility about the transparency of the courts, et cetera, et cetera, et cetera, the Supreme Court is going to ask the obvious question. Well, what does the subject of the videos think? What do the subjects of the videos think? And their legal representative is going to say, well, they don't want it released. And the Supreme Court's going to be like, so what's the public outcry about? And then, of course, if they remand it back to the district court for more evidence submissions, the problems with what's been represented to the court here, that will become very apparent very quickly. So.
Of course. Mr. Bromke, you will have 5 minutes for rebuttal if you choose to use it. Mr. White, I understand from our coordinator here that you're intending to split time. I didn't receive a notice that's what the intention was. Is that correct, though?
That was correct, Your Honor. But Mr. Baker's late arrival may prejudice him against his ability to respond to the questions the court asked the appellant.
What would you like? I'll just say, what would you like to do?
I'll handle it all, Your Honor.
Okay.
Okay. So yes, the county attorney either didn't show up or maybe showed up late. I'm not 100% clear on whether or not he showed up at all. But my attorney, Francis White, was going to handle the whole argument. If the county attorney showed up late and missed a significant portion of the appellant's argument, he won't be able to respond to what the appellant said. So him talking wouldn't be very useful anyway.
All right, Mr. White, you'll have 15 minutes. Go ahead, sir.
Thank you, Your Honor. Your Honor, my name is Francis Herbert White III. I'm here on behalf of Nicholas Rekieta, who is the defendant in the underlying criminal case and one of the respondents in this matter. As a defense attorney, I find myself in the very strange position of being on the same side of the V as the state. I never really thought that would happen, but here we are today. And like the court is, I don't understand, the court has expressed to Mr. Bromke, I do not understand by what authority Mr. Bromke has brought on behalf of Mr. Hardin this action in this court, especially when you consider the fact that shortly after initiating this appeal, sending this matter up for an appeal, he filed the public access lawsuit in the district court, which would be the more appropriate venue for answering these questions. I agree with the court that the rule that the Supreme Court issued under MDES is in fact binding upon this court and is in fact binding on all of the courts.
Can you help me understand when this request came in, every time the district court had to consider this request or the intervention request and the request for the documents, did you and your client have to appear at those hearings?
Patty Leather, I did not appeal my criminal case. Well, I mean, I did appeal I appealed the denial of the Franks motion at Omnibus. This is before my conviction was completed. We lost that appeal. That's, why I ended up pleading guilty, is because our main attack on what was there was a procedural attack on the warrant. The facts as they were that I had a bunch of drugs. that was the facts. That was accurate. And so I pled guilty once my rights were exercised and my procedural options were completed. This is a separate appeal specifically for the purposes of trying to obtain the body cam footage that is being done by Matthew Hardin at the request of Joshua Moon.
As far as I know, there were no hearings.
There are no hearings. Okay. And Marby Dog 65, Marby Dog says, another woman judge. Are they all women now? No. Two of the judges on this panel are women and one is a man. And so did this procedure delay the resolution of your client's case?
Well, I'd like to remind the court that my client is still under the jurisdiction of the court because he has a stay of adjudication. So despite Mr. Bromke's assertion that this case is quote unquote more or less over, it isn't more or less over. There still are criminal sanctions that are potential. And therefore the case is still, I wouldn't call it pending, but it's not over.
Well, before the stay of adjudication was entered,
this is kind of an interesting point raised by my lawyer. Technically, my criminal case is not over because my criminal case involves a stay of adjudication and probation. And that during the pendency of that probationary period, I am under the court's authority and I have to abide by the probation agreement. And if I were to violate that probation agreement, the court would exercise its jurisdiction and it would be under the same case as a probation violation. So my case is technically ongoing. And then the final resolution of my case will be at the end of probation if I successfully complete probation, the judge will enter in an order that will dismiss the charges against me. This is one of the really big perks of the plea agreement that was kind of critical to everything. A stay of adjudication means that I'm not adjudicated guilty. I'm not convicted of this crime. I pled guilty. The court heard the plea and rejects the plea, and instead offers a stay of adjudication on the condition of probation. If I successfully complete probation, I will never be convicted of this felony, and it will be dismissed as if it were dismissed on day one. It has the same legal effect, which means I will not lose my rights to firearms. I won't lose my right to vote like I can currently vote because I'm not convicted. If I were convicted and there was a stay of imposition, or if I was convicted and pardoned, that would be a different question. But this allows me to preserve my rights and to not actually have a felony conviction on my record ever. I'm not convicted now, for example, and I never will be, assuming I don't screw up the probation terms, which so far are going really well. I've completed all the things. It's just for the rest, for the duration of probation, which could be as much as 5 years. It could be kind of as little as 2.5 years. I just have to do the random drug testing and alcohol screening, which so far has been no problem. I don't assume it will be a problem in the future.
Was there any delay associated with the processing of your client's case associated with these requests? I'm just wondering how this worked. This is a very odd procedure to me.
Your Honor, I am not in a position to answer that question, because any delay that would have come from there would have been on the state of Minnesota, not on me. Mr. Bromke's communications with the state of Minnesota, I was entirely unaware of them until I had been informed by Mr. Baker that they were in fact.
So this is another thing that they try to do. They filed this request administratively to get these documents, which means they did this in a separate proceeding. Then we were not informed. Nobody who is in that video was served at all. And there are several non-government people who are in that video that are not in my immediate family. And those people weren't served either. No one was provided notice of this. And I think, that may weigh against them in this case and the other case, because it goes towards the dishonesty of the action. If you're presumably trying to get, body cam footage that someone has a privacy interest in, you would notify them or reach out to them. And that never happened. So that's another reason why any access to this body cam footage existed at all. If they had notified us, and I think Josh knows this, we would have posed it from the start. The improper filing would have been noticed right away, or classification that was done by the county would have been noticed right away and corrected prior to anyone being able to see this.
Asking the court to do something. I did not know anything had transpired before that, because there is a different procedures, an administrative type procedure to which Mr. Rekieta was not joined as a party. So while Mr. Bromke is here objecting to the fact that he wasn't allowed to assert his constitutional rights to a right of access and afforded due process, the same could be argued of Mr. Rekieta in that administrative hearing. He got an order from the court granting the limited access that he had without Mr. Rekieta being put on notice that access was even being sought. So there are two different constitutional provisions here at work. One is the constitutional right of a defendant to due process and equal protection, as well as a First Amendment question. And if
Is it your position that requests like this are critical stages of the proceeding for which a criminal defendant must be present for the consideration of the release of records?
So this is an interesting question by the judge. And again, this stems from the main problem, which is this doesn't happen this way. Typically, this is very unorthodox. It's not, there's not a rule allowing it or whatever. She's asking, should I be required to be present at the hearings about this release of information, et cetera, et cetera, et cetera? But again, it's not actually part of the criminal proceeding, and there was no notice given. And then there are other issues involved, potentially Fifth Amendment issues, et cetera. And you start to see why it's, an issue. You start to see why it's an issue maybe to have these body cams being publicly available. They complicate defenses because like, let's say someone makes a statement against their own interest on body cam footage. Happens all the time, right? Did you burn down that house? Only because that bitch was inside, right? Like there's something like that. Things like that happen with relative frequency. Or, you get body cam footage of drunk people acting stupid, or something gets seen on body cam footage that maybe the officer didn't notice at the first pass. And then that body cam footage's public release would allow the police to then use that body cam footage and any statements made. They may be able to get that into evidence in a different way. The problem with this is maybe it's not actually admissible in and of itself. And you don't get to argue that if there's this big public discussion about what's going on. This is where the complications come in with all this. And there's severe Fifth Amendment implications going on, and even Sixth Amendment implications going on as well. When you get into the right to cross-examine your accuser, if there's public access to body cam footage during the pendency of a criminal action, and someone talks about something publicly, like on Twitter, or makes a YouTube video about something that happens in the video, and the prosecutors see that and then utilize that in part of their argument, then the original claimant is actually the person who made the statement, the YouTuber or the blogger or whatever, Twitter user, and you don't have a chance to cross-examine that person. The state just incorporates it into their argument. That's a huge problem. There are constitutional implications to that. So even Florida's sunshine laws, they carry those potential issues while an action is pending.
Not necessarily, Your Honor. It is my position that the defendant should be notified that there is a request. I fully agree that the district court has it within its authority whether or not there should be a hearing or not, or whether it will just accept submissions on the record. I haven't seen any governing authority that requires a district court to have a in-person or a Zoom hearing when the record suffices. As a matter of fact, this court very frequently, if a party is unrepresented, will not schedule oral argument. Those people are not deprived of due process by just deciding the information, making the decision on the briefs alone, even though the parties didn't get a chance to present oral argument.
Mr. White,
Cyborg Valkyrie, I believe it was May 1st. I'm not 100% clear on that, because again, I wasn't served in that. I wasn't served in that action. No one was notified at all, even though there's a serious privacy right being implicated there. Now, I see New York Renal MD says that he doesn't see any standing issues. Standing is a federal issue. It's not a Minnesota issue. So you've got a problem there about standing. There is, in the Government Data Practices Act, a specific privacy interest that's created by the status that the videos are confidential and then private, subject only to the consent of the subjects of the video. So you have a privacy right generated by statute, if nothing else, but generally you do. Now, if someone contests, like in this case, that, these should be released because they're evidence or whatever, like if they make that contest, that contest and say that, then the person should have the ability to respond to that. they should have the ability to say, "You're not." The judicial might be wrong, they'd be right, whatever. But that would be, the process by which rights are properly balanced against each other to determine if they're there in the first place and which one wins if they are. So I'll disagree with you on that. That again, there's a reason that the appellate court judges here are going, why did you do it this way? Why is this the case? We've never seen this before. And that's because it was done in a very strange way. And usually in a case where you're looking for body cam footage to be released as being held by the state, the defendant or the subject of the body cam footage is on the side of the people who want it released. They're usually on the same side, and the state is opposing it because of public perception, a fear of violence or something else, or because they found something improper that they're trying to cover up, stuff like that. Usually that's the case. This is a unique case. And I'm not saying that this case, that this use case scenario doesn't exist. This is going to become more prevalent, only more prevalent as social media grows and grows and grows, and streamers and content creators and whatever you want to call them start to have more and more run-ins with the law. We've seen a lot of them this year, and people are going to want to know. And so we may be creating, that's why I said earlier, you don't know how this is going to turn out, even though the legal foundation that exists right now is pretty heavily in my favor. But you don't know, because courts haven't dealt with this issue before. But the appeals court isn't the place that they'll win that argument. Typically, it will have to go up to the Supreme Court. And the Supreme Court can choose to change their precedent and address, maybe the new public policy argument or new information or a new angle that they hadn't considered before. Those are all reasonable things to do. Is just, again, at this stage saying I don't have the authority for it, and et cetera, that's a problem for their side.
Are you aware of any legal authority that would permit intervention in a criminal proceeding to seek access to case records in that proceeding?
No, Your Honor, I'm not aware of any that would prohibit, and I'm not aware of any that would allow it. The only records, the only thing that I would have to rely on is the order from the Supreme Court as regards to MDES. And as MDES works, it is a staging platform. And until such time as that evidence is offered and admitted, it's simply there waiting to become a record. It is not at this time a record.
And, counsel for the state isn't here part of the oral argument, unfortunately. But from the briefs, it appears that your client, as well as the state, is of the view that intervention wasn't appropriate. Can you respond to that question or comment on that point?
Yes, Your Honor. The rights of a party or an individual to intervene in a criminal case should be reflected in the rules of criminal procedure. Now, I do know that when you appeal a criminal matter to this court, you sometimes rely on the administrative rules of civil procedure, but that's because there are no other rules that guide that. I'd like this court to think of what the consequence would be to allow intervention in a criminal proceeding beyond what Judge Frisch has suggested might actually happen in the delay of criminal adjudications. It would open up an argument for individuals to potentially initiate private prosecutions. Now, there are a lot of people out there who would probably love to engage in a private prosecution, particularly of government officials with whom they disagree. But that would create a problem, not just with the courts, but with the due process of the individuals who are being charged privately. I think by allowing non-parties to enter into a criminal proceeding, you are opening up a Pandora's box that will have a sort of Damocles over the judicial system.
Thank you. With regard to the legal issue in terms of access to the records that was decided by the district court, what standard of review do you think is applicable to the district court's decision to deny access?
That's an excellent question.
Okay, so it is an excellent question. It is. And look, I like my lawyer a lot, but I have some stylistic critiques. I'm not the biggest fan of how he starts the answer to this question, even though he gets to the correct answer, which the correct answer here is abuse of discretion. And he will get there. But first he's going to say something about he would normally do this. This is just a stylistic difference, a rhetorical style that I don't prefer. I prefer to be much more direct in my arguments. But, this is one of the reasons you hire someone else to represent you, even if you could theoretically represent yourself, because your stylistic preferences may cloud your judgment in the moment. When you're working on behalf of a client and you have kind of a 20/20 view of their issues removed from them, you can rely on your own style or modify it as you see fit. Whereas if they're your issues, like for me, I'm like, no, I want to hit this and this and this and this and this, because this, this stuff at this point in time, I've cycled through this for well over a year of, a year and a half now of time since the arrest. So like I've thought through this. I have my own prejudices as to how things should be presented and what things are important and not. And he has a different perspective. That's why you hire someone, even if you could like have the training to do it yourself or whatever.
Your Honor, as a defense attorney who's normally on the other side of the V, I would argue that this should be granted de novo review. But I don't think that's proper.
See, my personal theory is don't propose something and then say you don't think that's proper, because the court might just disagree with you. But if you don't propose it, it's not in the record. You just say, hey, I think this should be abuse of discretion, and you don't even bring up de novo review. Then, the court could say, well, counsel suggested abuse of discretion. However, this court disagrees. This court suggests it should be de novo review. De novo review means that they look at everything in the record from scratch, fresh, as if nothing has happened, and make their own legal determination based on the facts that are in front of them, right? That's what de novo review is. That's very broad. That allows the appeals court to interpret things from the evidentiary record in their own way. Abuse of discretion defers to the trial court. Sorry, defers to the trial court's observations and interpretation of any evidentiary issues that have come before it, and defers in some ways to its rulings of law, except for the matter in question. And then what it does is it takes the matter in question and it says, okay, is there a rule clearly on point for this determination made by the judge? If there is, was the rule applied properly? If not, is this a question that is within the discretion of a judge to resolve? So again, this is like things like objections, right? You object to the introduction of evidence. Well, the admissibility of evidence is discretionary for the judge. They have some interpretation on relevance and stuff like that. To find abuse of discretion, you have to say, okay, this is within the discretion of the judge, and the judge abused that discretion, which means they go beyond a clear error and into an abusive use of their discretionary authority. Abuse of discretion is a pretty high bar to meet, and a lot of deference is given to the trial court judge. So that's why you want that as the standard versus de novo. So that's the difference between our arguments. But he got, like I said, he got there eventually.
Because there is no legal authority that was applied to the case to allow intervention, I think an abuse of discretion standard would be there. The appellant has not been able to cite to any authority that would grant him the relief that he sought. Therefore, I don't believe that de novo review is appropriate because it's not really a question of law, because he can't make it a question of law.
I'm sorry, Judge Kirk, were you about to ask a question?
No,
Appellant also argues, or counsel for appellant argues, that the district court reviewed these videos and therefore they are now court records that should be accessible. Can you respond to that argument first?
Okay, real quick, there's some further discussion going on in the chat about the government's access to this thing. So they said, doesn't the Cyborg Valkyrie and the chairman Lamau, makes me laugh every time, have asked/suggested that the government, does the government have access to this stuff beyond the 90 days past the investigation? And the short answer is sort of. There is the possibility to request that the records of it be destroyed. That can happen after the 90 days. The question is the investigation technically over? Is the real question, because in theory, maybe based on probation violation or whatever, the judge could revoke my plea agreement, or in theory, I guess, I could attempt to withdraw my plea agreement so long as the case is still pending with the stay of adjudication. You can make an argument that the investigation is still ongoing for that purpose. That's a thin argument. I don't know that you would win that argument, but if that's the case, then technically this is all confidential and this is all a whole separate problem. The government, the Minnesota Data Practices Act has a policy for the destruction of body cam evidence. It is stored for a period of time, and then, which is the 90 days past the ending of the investigation. And then each department head or commissioner or Data Practices Act agent in each specific county or district has the ability to set up a routine destruction of existing evidence or existing body cam footage for the purposes of, technological economy, freeing up space and removing clutter. So they have a policy for it. It's different county to county. I don't know the specific policy that our county has. For example, it's a very small county, and this is one of the first Data Practices Act issues that our county has dealt with ever on body cam footage, because it doesn't come up in small counties. Much more common in Hennepin or Ramsey County, where Minneapolis and St. Paul are. I think it's pretty obvious why. Higher populations, higher crime rates, stuff like that. Here it's not as frequent. So I don't know what those policies are. We haven't had to make that argument or anything at this point. But there is a point in which the government should have a procedure to destroy that data. They don't keep it around forever. It's just a question by county and district of what that policy actually is.
In terms of whether you think the record reflects that the court did review the videos, and if so, when, and then second, does that change our legal analysis in terms of the Supreme Court's order on relating to Mindy's?
Yes, Your Honor. To begin with, I don't believe that the district court reviewed the videos, at least in the criminal proceeding. I can't speak to the other proceeding because my client was not privy to it. However, in the criminal proceeding, it was not reviewed. And it is clear that it was not reviewed because there's nothing in the record that says that it was reviewed. And the district court judge clearly stated in his order that he did not base his decision on the videos. Mr. Bromke has suggested to this court that the district court judge's assertion that this was more appropriate for a motion in limine proceeding is misguided, and proves that he must have reviewed the videos is misguided, because any judicial officer in this state can glean that exact concept from the actual brief that I filed, where I put in there the specifics of what I was asking the court to do. I asked the court to review this, and if you look at the transcript, you can see in the transcript he did bring that up, and I said I wanted to make sure that this was timely, because I had found another case, I believe from this court, that had stated when somebody brought it up in a motion in limine, they had that, and they should not have brought it up. They should have brought it up sooner, even though the district court was wrong. That was not reversible error. That was harmless error. So I agree with the court. It's not in the record that he reviewed it. There's nowhere in the record that he reviewed it.
Well, in terms of the omnibus hearing, but I think the court's order.
So this is where the judge is trying to resolve this conflation that the other attorney tried to pass off here, right? Which is that the court didn't review this in the criminal case. They reviewed it in the administrative case that was filed on May 1st, I believe. And he said they reviewed it in both cases, which is not true.
Initially granting access suggests that the court did review it, because it talks about the contents of it in terms of there being children present when the search warrant was executed. So and that is in Mr. Hardin's addendum, I believe, at pages 22 and 23.
Mm-hmm.
So does that change our analysis in terms of whether that, given the administrative error in marking it admitted and then the court's review for purposes of the records request, in terms of whether the Supreme Court's order on Mindy's applies?
Your Honor, I don't think that that order gives us heavy lift as the appellant is suggesting, because there was a previous filing in the criminal case that I filed where I objected to individuals who had filed a request to record the omnibus hearing. And in my brief, I said that there were children present. And I do believe I said there were children present in the body cam video, and that
He did. And I remember this very explicitly, because this is this is another part of the case that's really important. And it speaks to why the child endangerment charges were ultimately dropped. And that is in response to his statement that there were children present in the body cam footage and that there are, children involved in this case. The county attorney sent a letter to the court, and that letter says there are no victims in this case. This crime is not a victim crime. If that doesn't tell you all you need to know about the posture of the county in regards to child endangerment charges, if you don't have a victim of child endangerment, you don't have a crime. You would have to have a child who is endangered or a child who has the potential to be endangered to have that. And the county attorney specifically stated there are no victims in this case. It is not a victim crime at all. So that was, part of the issue there. That's why I remember specifically that he mentioned it.
brief. This was prior to my brief on the omnibus itself, I believe. So the court could very well have gleaned the information that there were children present from that, unless the district court specifically stated that it reviewed that. And finally, Your Honor, I would like to say this is more appropriate for the Data Practices Act. I looked at one of these two proceedings is a collateral attack on the other. This is not a proper proceeding before this court. The district court can access this under the Data Practices Act. The plain language of the Data Practices Act says that it doesn't apply to judicial records. Judicial records are governed by the judiciary. And the Supreme Court of this state has spoken just to that. As far as
there isn't any legal bar to someone seeking a record that might be retained by the executive branch and the judicial branch at the same time that I'm aware of. Are you aware of any? I mean,
this is another mild criticism I have of my attorney, who I think did really well overall in this oral argument. But I think he spent a little too much time focusing on what he's calling a collateral attack. And the judge here rightly calls him out on it and says, is there any rule preventing you from requesting something from the judiciary and the executive at the same time? No, there isn't. So, you know, as far as I am aware, in this case, it's if they want to say it's either evidentiary records or it's governed by the Data Practices Act, that's fine. I think the law on both of them comes to the same conclusion, but it's different questions for different branches of government. And I don't see a problem with asking both of them, even if it is ultimately annoying. And like I said, I think he got, I don't want to say, like, I don't know that he got caught up on it. That's the question that they asked him. So he's responding to it. I just don't think the collateral attack is that, you know, like, I don't think it's that impactful. And I think that, you know, words on paper and words spoken could have been dedicated to something else. But if the court is asking about it, it needs to be addressed. So I think he did a good job addressing it. I just don't think that they're, you know, I don't think it's on the best ground there, in all honesty.
are you aware of any law that would preclude submitting two requests, one to the executive branch and one to the judicial branch?
I'm not aware of that, but as I stated before, one of these two is a collateral attack on the other proceeding. I see my time has expired. Unless you have any more questions, thank you, Your Honor.
Is there anything else from the panel?
No.
All right. Thank you very much, Mr. White. Counsel, you'll have 5 minutes for rebuttal.
Thank you, Your Honor. A motion to intervene is appropriate to assert the public's right of access in criminal proceedings. I've got some federal case law in here.
Okay, so he reserved 5 minutes of his time. He only went 10 minutes prior. Now he has 5 minutes left over for his rebuttal. So he's going to try and clean up anything that he thinks he missed. Here's where he spent that time going through his case binder and trying to find a federal case on point, which would allow private intervention in a criminal matter. Again, he's not going to find anything in Minnesota. I believe he's going to find something in the Second Federal Circuit. He'll talk about it in just a second. It's US v. Farah, F-A-R-E-H.
The Herald Company, 734 F. 2nd 93-102. Vindication of the right of public access requires some meaningful opportunity for protest by persons other than the initial litigants.
Was that a criminal proceeding?
Uh,
I mean, my concern is that in the civil rules of procedure, there are specific rules that allow for intervention, permissive intervention and intervention as of right. But there aren't corollary rules in the rules of criminal procedure. And I don't think in the rules of federal rules of criminal procedure either. Oh, I could be mistaken. I'm not as familiar, obviously, with the federal rules. Is there some authorized procedure here?
With respect to the rules of criminal procedure in Minnesota, I think we've established that there isn't a specific rule that allows for intervention of that type, but this isn't some improvised procedural maneuver. It's a routine nationally recognized method for vindicating a constitutional right that belongs to not to the parties, but to the public.
So he's arguing here, just getting back to the case, that this is not some improvised procedure, even though he literally is saying that it doesn't exist in Minnesota's rules. So it kind of is an improvised procedure. That's what he's going with. Again, he's on really shaky ground on all of this stuff. And he cited some cases. All of them were civil cases except for one. And that's where the judges are having a problem. They're like, the cases that you're citing don't actually stand for the proposition you're trying to achieve. That's not a problem, though. Lawyers do something called synthesis, where you take a couple different ideas from different things, you synthesize them together into a new thing, and then you make an argument by analogy that these things are like your thing, and the judges should treat your thing like this. So that's, this is just kind of part of the process that he's doing here. It's just not done well because he doesn't have a lot to draw on.
Though, I'm waiting to hear about criminal cases where this has been allowed.
I would request that the court grant some additional time to file some supplementary authority to that point. Just because the constitutional question here is an important one. It's the public access to criminal court records in a case where the defense and the prosecution have both taken the same position. US v. Arif 533 F 3rd 7281 is expressly criminal. The other conditions, or the other citations that I have pulled up here are appellate petitions for mandamus forcing district judges to grant mandamus. But in United States v. Arif 533 F 3rd 72.
Mandamus is a civil proceeding.
No,
Yeah. So again, he has one citation, US v. Arif. Again, that's AREF if you want to look it up. I thought about bringing it up, but this is going to get really, really heavy. And this stream's already going really long for the other stuff I want to do. But US v. Arif, if you want to look it up and read it because you're insane, you can. I'll just tell you flat out that the issues in US v. Arif are about prosecuting people in the context of being Islamic terrorists, or something akin to that, part of a terrorist organization, involve national security interests and documents that are literally concealed from the public during the prosecution due to the alleged national security interests. That's not happening here. The government here isn't withholding the body cam footage because of some other thing. It's because that's the law. The law is they're not allowed to release it. And these guys are trying to go around that law, although they're not stating it. They should just challenge the constitutionality of the statute, of the Data Practices Act, and then of challenge the judicial records rules as violative of constitutional rights if they wanted to do that. But they weren't so brazen as to really go for that.
Yes.
In US v. Arif, the court reaffirmed third parties seeking access to judicial records can intervene directly in the criminal case to assert that right. I believe that's representatives of the press. The court accepted the procedural route as an obvious, uncontroversial way of doing it because access rights attached to documents and proceedings in that specific file. And the district court should follow the same rule. It's a natural way of.
And what case is that? Can you tell me that case again, please?
United States v. Arif 533 F 3rd 7281, Second Circuit 2008.
All right, thank you very much.
Representatives of the press intervening to challenge closure and sealing orders inside a criminal matter itself is something that you would need to actually file into the criminal matter in order to do. So procedurally, it makes perfect sense.
And those were cases where there was a challenge to the closure of a courtroom?
I believe that case in particular, I'm not certain of the exact factual pattern underlying it, but...
Closure of a courtroom is different than requesting a document. And
that's correct. I was referring to some of the other cases I was going to be citing, but the United States v. Arif is an expressly criminal case. And the issue at hand is access by the public to documents in a criminal case.
I lied. I'm going to show you guys the first pages of US v. Arif as soon as he's done, because I want to show you, he's stating this now, but when the district court goes into the citation, or the appellate court, they're going to laugh because it's a really bad citation for his assertion. We'll read it. We're just going to look at the very beginning of it in just a second because the the order. It blows his analogous assertion out of the water.
So I would submit that that the same principle is applicable here, especially given the public policy concerns of two parties that are nominally adverse, trying to coordinate to restrict the public access to those records. Procedural rules can't be interpreted in a way that diminishes constitutional rights. I mean, the cases I cited, Sargent and Ledoux, hold that procedural rules can't do that. Schumacher and Star Tribune recognize a constitutional and common law right of access. The method specifically by which it's enacted, I think, matters less than the public's interest.
But you could still have a right to access through a writ of prohibition or a writ of mandamus, correct? So the question here is whether intervention is the appropriate avenue.
Whether it's the appropriate avenue, but whether it's impermissible, I would argue that it isn't. But in a criminal case, the most direct method of gaining access to specific records you want is simply to file into the criminal case itself. I recognize I'm out of time, so.
Anything else from the panel? All right, thank you very much, counsel, for your helpful arguments and submissions. The matter is submitted. We will issue an opinion within the statutory time period. Thank you.
So there you go. Statutory time period is 90 days. So they have until, as stated by Cyborg Valkyrie, they have until mid-February on that. Now let's take a very quick look at US v. Arif, which is Yasin Muhyiddin Arif and Mohammed Musharraf Hussein are the defendants, and the New York ACLU is the proposed intervener appellant. So there, in this case, Joshua Moon is trying to do what the New York Civil Liberties Union is trying to try to do in this case. Now, here's the summary of the case and what happened. Again, we're not going to get into the analysis and all that. We're just going to look at the summary and the issues that are there. It's laid out right up front. I went and checked. The defendants were convicted after a jury trial in the Northern District of New York. The district court denied a motion of the New York Civil Liberties Union, the NYCLU, to intervene in the case for the purpose of asserting a First Amendment right to discovery of certain documents sealed by court order. The defendants and the NYCLU now appeal. So in an accompanying summary order, we reject most of the numerous challenges to the district court's rulings. In this opinion, we hold that first, pursuant to Section 4 of the Classified Information Procedures Act, 18 U.S.C. Appendix 3 and 4, a criminal defendant is entitled to discovery of relevant classified evidence that is helpful to his defense. A decision within the district court's discretion that may be made without the defendant's or his lawyer's participation. So if you are, if you are being prosecuted and there are classified documents, you are entitled to discover those documents. Notice this is not necessarily about the public release of those things. This is where their first issue runs in. The body cam footage is not being withheld from the discovery process. It is not sealed and classified. I have them. They've been turned over to me as part of discovery. 2, so Section 2. We review denials of motions to intervene in criminal cases for abuse of discretion and find no such abuse here. So the level of review, abuse of discretion, again, that's what Francis ends up suggesting. My lawyer, Francis, ended up suggesting is abuse of discretion is the proper standard. And they agree here. Them finding no such abuse here is irrelevant to our case because it's fact specific at that point. And 3, district courts ordinarily should refrain from entirely, as opposed to selectively, sealing court orders and documents filed by the parties. But the district court did not err in doing so here. So you've got a case that says that, generally speaking, they shouldn't seal a whole file, but they did seal a whole file, and that was fine. This case is not good for Moon's case. Like this case has two major issues for them, and that's issue 1 and issue 2. Issue 1, there's no discovery disclosure problems here. Everything was properly disclosed during discovery. Like that happened in regards to the body cam footage. And then number 3, they shouldn't always seal everything, but in this case, it was okay. In my case, nothing is sealed by the court. The court doesn't seal it. There are rules about what is and isn't evidence. Those rules govern what happens with the body cam footage, or alternatively, it's governed by the Data Practices Act. On both of those issues, they lose. So unless they find and determine that the rule is improper or something like that, that would be the thing. But that's not what they're arguing. They're arguing that this, is when they're using this case, they're trying to draw an analogy between a court sealing it and rules existing that just say, yeah, this never entered the court at all. They've got a huge problem. So US v. Arif, not a great case for them. So yeah, that's that. Sorry that it took so long, but there's a lot to say on it. Again, this is a new area of law, at least insofar as Minnesota is concerned. And even in the places where this law is exercised, it's rare to have the same posture as we have here. So you notice in US v. Arif, as we were talking about, the defendants are on the side of the appellant, whereas in my case, I'm on the side of the respondent, not the appellant, because my posture is with the state's posture. And to be very clear, the state's posture on my case is neutral. It's just applying the law. Because if the state violates the Data Practices Act, they have a big problem. There's a cause of action for that from me towards the state. That is not a good thing for them to do. So they're just generally on that. There's never been any indication that they have a moral or judgmental position one way or another, that they want to keep the body cam footage quiet or they want to release it. I think they would likely be happy to release it, except the law restrains them. You can assume that laws restraining government, the government typically would want to do the thing. But I don't know. That isn't an issue in this case that has been brought up. So the government's not like aligned with me because they're like, oh yeah, we want it. Like that's not anywhere to be found. So the only inference is this is how they apply the law. And if the court told them otherwise, they'd be happy to do it. In fact, when the court did approve the limited release, like they just did it. They did it no problem. Like that. They're like, oh yeah, that's fine. They didn't levy an opposition to it. They didn't they didn't take a position at all. They just went with what the district court said. So now the district court says, you need to do it this way. That's their position. That's fine. Boomer Fox says 3 hours on a BS claim from a tard with TISM. Is 3 hours for y'all. Imagine how long this has been for me. Oh,